So Article 3, Mother, document volume.
So they delete effectively the proviso to Article 3. But Mr. Sabal, at the end of it all, I mean, of course, this has the optics about the way it was done, but there's no challenge to anything that was done. All this is not under challenge here.
No, Mother, once you are challenging the emergency, Mother, the declaration of 356 is challenged. Mother, just look at it.
What is the frame of the petitions? Do we have a challenge?
Yes, we have one challenge. But Mother, quite apart from that, you're looking at Mother, it's in grade 370, Mother. I mean, it's not.
All right, we just see what the frame of the challenge. If you can just ask one of the juniors to make that little tabulation for us.
But apart from that, Mother, this is now before you.
Yes.
In all its various nuances, in a sense.
Yes, of course.
Now the question is, Mother, what is the power? And that's the other thing. What is the power under 356? The quintessential object of 356 is to restore democracy. You take over because a government cannot be run in accordance with the provisions of the Constitution for a temporary period for the restoration of democracy. You don't use 356 for its decimation. You can't amend the provisions of the Constitution under 356. Of 356. We'll give it on Tuesday. We have to show the Constituent Assembly.
require ratification by the state legislatures. Now, suppose a particular state, the legislature, the power has been exercised under 356 and the president assumes the powers of the legislature, the executive. Can a ratification be done under 356 in relation to that particular state legislature?
No, Malaj. No, because he's exercising powers of the state legislature, Malaj, in this sense. There is no question of ratification.
Not in the J&K case. I'm
Yes.
just theoretically, I'm saying, can a
Generally, what is my lord is putting to?
some constitutional amendments under the proviso
Yes.
require a ratification.
That's right. That's right.
Now, for the purpose of computing the majority, computing the strength required for ratification,
Yeah.
can the center fall back upon the exercise of the 356 power? Say that, look, we have ratified it because we were exercising the power under 356.
Tough question.
Has never
What my lord is
happened, but
putting to me is that if Jammu and Kashmir, in a 368 situation, if Jammu and Kashmir were to ratify it, then Parliament can exercise that power.
suppose any Indian state,
No, Malaj.
you require a certain number of states.
Provided, Malaj, the 356 is imposed there, not otherwise.
But if 356
Yeah.
is imposed, then can that power to
That's-
ratify the
that's a tough
amendment be
question.
exercised?
That's a tough question.
Even that is a little.
Yeah, it's a tough, I can't answer it.
yeah,
right
even
away.
I-
I'll have to think
just-
more
I-
about it. Because the ratification is of the state, therefore there are two separate constitutional authorities. One Parliament passing the law and
And then the
another
state.
authority ratifying it. You can't take the position, that's like, it takes two hands to clap. It's the same analogy. Therefore, you can't exercise that power yourself because that's power constitutionally is provided for in another institution, in another constitutional body.
Now here the proclamation comes under 356.
That's right.
After that, what is done then?
Then, Malaj, they amend section, Article 3.
We saw that.
Yes. But Malaj, kindly see, just read Article 3 with me for a minute. Formation of new states, alteration of areas, boundaries, or names of existing states.
Amendment to Article 3 required as part of this whole process.
Because they wanted to get rid of this proviso, Malaj. Otherwise, they wouldn't have
Let's
been
see the
able to.
proviso.
Yes. Because then you have to do the Reorganization Act.
Or the reorganization.
Yeah, that required.
Converting the state into a
That's
UT.
right. That's right. That's how this had to be done earlier. Second proviso is not your lordship's document. That has been the other document. The second proviso relates to Malaj as applicable to the state of Jammu and Kashmir. Kindly have a look at that. Kindly just show that document.
Document volume 1.
Volume 1.
Of the order passed.
Yes. There the proviso is there.
There the proviso was.
That's correct.
That proviso is deleted.
That's correct.
Which is that proviso?
Which requires, I'm going to show that to you, Lordship. PDF page 65, document volume 1.
That
Yes.
must be pursuant to the presidential order.
Correct, absolutely right.
So the presidential order was was the presidential order amended? No.
No. That's interesting.
It has been superseded, my lord.
It deals with the second proviso. You can't even introduce the bill, forget about anything else.
Or only one second proviso.
Second part of the first proviso and the second proviso.
Where do we get this document? Actually, it's document number, document compilation.
Documents, volume 1, PDF 65.
65.
Constitution of India as applicable to the state of Jammu and Kashmir.
At page?
PDF 65, running page, Malaz, is 65, also 65.
That's the Constitution of India is applicable to the state of Jammu.
That's where the only place where the pages of the Constitution of India and the Constitution as applicable synchronize, Malaz. The rest is.
I interestingly read the note below. It says when secular was inserted into the Constitution,
Yeah.
it was never inserted here.
Never inserted, okay.
Just see the note below
I
it.
got
Note,
it, I got
note 1, you got it?
Yes, I got it at the bottom, yes. Socialist, secular.
Socialist agree.
But see, Malaz, what they've done.
Where is the proviso?
Proviso, Malaz, at page 66, next page.
Second proviso.
Let's read the whole, Malaz. It'll be better
Yes.
if we read the whole, if you don't mind.
Yes.
Formation of new states and alteration of areas, boundaries, or names of existing states. Parliament may by law form a new state by separation of territory from any state. Malaz, this is also be important when you deal with the Reorganization Act. You might as well read the whole article, Malaz. Parliament may by law form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament, except on the recommendation of the President, and unless, where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views thereon, which within such period as may be specified in the reference, or within such further period as the President may allow, and the period so specified or allowed is expired. That's why, Malaz, when the views of states was taken, Malaz, they said, no, you haven't referred it. We said, only need to take your views. We don't have to take your consent or your concurrence. So we may not agree. Even if you express your views that it should not be done, we're not bound by, which is the correct constitutional provision. Then the second proviso, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. So you can't even introduce it. Here by 356, you do away with it.
They have created a UT. Otherwise, they have not altered the territory, have they?
No, they have, Malaz.
No.
Ladakh is not part of the state anymore.
That's what they carved out a UT and
Yeah.
made another UT, which they say.
They have carved out a UT saying that this will become a state,
Yeah.
and the other UT will remain a UT.
UT. So carving out a UT is permissible, no?
The boundaries
No,
are.
not from a state. I'm sorry, you can't
Boundaries
create
are
a
altered.
whole state as well.
Boundaries are also.
Yes,
altered.
boundaries are also altered.
To that extent, yes.
So, Malaz, this is all. And Malaz, there is and I'm going to take your lordships to the Constitutional Assembly debates on this. Just presently, I'll do that.
And for J&K, consent is required.
Yes.
Not just
No,
the views, but
Yeah.
the consent.
Consent.
Other states,
No, Malaz, you require the consent before you introduce it.
right.
Yes.
Other states, it's only the views have to be taken,
That's-
but for J&K, the consent is required
Before you
to introduce the bill.
Yes. I'm sorry.
Okay.
Is it mentioned only in 1954 constitutional order, or is it incorporated in Article 3 also?
It's mentioned in the 54 order and incorporated in Article 3 before the 54 order.
If
Yes.
it is incorporated,
Yes.
that would amount to amendment of the constitution. Then was it followed as per Article 368?
Not in the Indian Constitution, Mother. It's only in
Article
this Constitution.
This proviso, second proviso,
Yes,
you are reading.
yes.
Now we are reading it on the presumption or assuming that it's a part of Article 3 of the Indian Constitution. Second proviso.
No, it's a modification of Article 3. As applicable. As applicable only.
So it is only incorporated in the 1954 order,
As
not formally inserted in Article 3 of the Indian Constitution as a second proviso.
Correct, correct, correct. Absolutely right, what my lord is putting to me. Absolutely.
They suspended the operation of
They
it.
suspended the operation. Now, how do you get that power under 356? That's not the object of the proclamation.
Deleted, suspended.
Then the exercise.
That assembly can't exercise that power, Manas, to suspend.
On behalf of the assembly.
Yes, they can't do that also. A bill cannot be introduced without the consent. Assembly is not in session. There is no assembly, it has been dissolved. So where do you get the consent of the assembly? So the governor becomes the assembly, then the assembly becomes parliament, and then parliament gives consent. On behalf of an assembly that doesn't exist.
Mr. Sibal, what was the procedure followed when different orders were issued under those constitution, right? Like those about 18 orders,
Yeah.
constitution orders,
Yeah.
1952 up
Yes,
to.
all mandates with concurrence. With
What was the procedure followed?
procedure
Was it through parliament process or through by the president only?
No, it's not through a parliament process, it's through a presidential notification after taking the consent, concurrence or consultation. That's right. So that's how it's made applicable, through a presidential order. No. So it's 356 and exercising powers under 356. It's a Well, as in this context, before I go back to 356, it's better to your lordships looks at the Constituent Assembly debate on this. On this Article 3 and why this was Volume 8. PDF page 289. Which Dr. Ambedkar Maharaj at 289 says, "Sir, I move." Yes. There's sir, I move that for the existing proviso to Article 3, the following proviso be substituted. provided that no bill for the purpose shall be introduced in either House of Parliament except in the recommendation of the President, and unless where the proposal contained in the bill affects the boundaries or name of any state or states for the time being specified in Part 1 of the first schedule, the views of the legislature of the state, or as the case may be, of each of respect to the provisions thereof, have been as contained by the President and the states, both with respect to the proposal to introduce the bill and with respect to the provision thereof, has been ascertained by the President, and where such proposal affects the boundaries or name of any state of states or states for the time being specified in Part 3 of the first schedule, the previous consent of the state, or as the case may be, of each of the states to the proposal has been obtained. Mr. Vice President, if one were to compare the amended proviso with the original proviso, as it was set out in the draft constitution, members will see that the new amendment introduces two changes. One is this: in the original draft, the power to introduce the bill was given exclusively to the Government of India. No private member of Parliament had the power under the original draft to propose any legislation of this sort. Attention of the drafting committee was drawn to the fact that this was a somewhat severe and unnecessary curtailment of the right of the members of Parliament to move any motion they liked, and in which they felt concerned. Consequently, we deleted this provision, giving the power exclusively to the Government of India, and gave it to the President, and stated that any such bill, whether it was brought by the Government of India or by any private member, should have the recommendation of the President. That is one change. The second change, which is more important, is this: under the original Article 3, the power of the Government of India to introduce legislation was restricted by two conditions, which are mentioned in A1 and 2I. The conditions were that there must be, before the initiation of any action, representation made to the President by a majority of the representatives of the territory in the legislature of the state, or a resolution in that behalf passed by the legislature of any state, whose boundaries or name will be affected by the proposal contained in the bill. Here again, it was represented that there might be a small minority which felt very strongly that its position will not be safeguarded unless the boundary of the state were changed, and that particular minority was permitted to join their brothers in the other state, and consequently, if these brothers remained there, action would be completely paralyzed. Consequently, we propose now in the amended draft to delete 1 and 2. This is important. To delete 1 and 2 of A and also B of the original draft. These have been split into two parts, A and B. A deals with reorganization of territory insofar as it affects the states in Part 1. That is the Dominion states. Part 1, that is to say provinces, and of the new amendment relates to what are called Indian states. The main difference between the new clause A and B of any amendment is this: in the case of A, that is to say reorganization of territories of states falling in Part 1, all that is necessary is consultation. Consent is not required. All that the President is called upon to do is to be satisfied before making the recommendation that their wishes have been consulted. With regard to B, the provision is that there shall be consent. The distinction, as I said, is based upon the fact that as far as we are at present concerned, the position of the provinces is different from the position of the states. The states are sovereign states and the provinces are not sovereign states. Consequently, the government need not be bound to require the consent of the provinces to change their boundaries. While in the case of the Indian states, it's appropriate in view of the fact that sovereignty remains with them that their consent should be obtained. As regards the amendment moved by Professor Shah, I do not see much difference between my amendment as contained in subclause A of the new proviso and his. He says that the discussion shall be initiated in the states. My subclause A of the proviso also provides that the states shall be consulted. I have not the least doubt about it that the method of consulting which the President will adopt will be to ask either the Prime Minister or the Governor to table a resolution which may be discussed in the particular state legislature, which may be affected, so that ultimately the initiation will be the local legislature and not by the Parliament at all. I therefore submit the amendment of Professor Shah is unnecessary. Now, this was adopted. So the views of the people of the state were to be taken. So the second proviso, Malaz, when it came in, they said that this will not apply to Jammu and Kashmir. It needed consent. And so therefore no bill could be introduced. This is consistent with all of the provisions, including 370, including the powers of concurrence, Malaz, with respect to the concurrent list in the concurrent list of the Constitution as applicable. So this is a consistent thread throughout, which is accepted by the Constitution makers. So now, Malad, if you now go to 356, document volume 3, no, this is very, PDF page 92, I'll read further, Malad. So they suspended this.
Document volume 3.
Yes, Malad, volume 3, PDF page 92. That's the proclamation. So when everybody was all states were integrated into the union, that means you didn't need any consent. But since this was not integrated, Jammu and Kashmir, therefore the second proviso was provided. And Millers, your lordships will see that the whereas clause says provisions of the Constitution of India as applicable to that state and of the Constitution of Jammu and Kashmir. Both. And now, Millers, so much of the first proviso to Article 3 as relates to the reference to the president to the legislature of the state, and the second proviso to that article, so much of clause 2 that we don't need to read that. Then, Millers, kindly item 3 of the proclamation. Any reference in the Constitution and the state constitution to the governor shall, in relation to the said state, be construed as reference to the president. And any reference in the Constitution and the state constitution to the legislature of the state or the houses thereof shall, insofar as it relates to the functions and powers thereof, be construed unless the context otherwise requires as a reference to Parliament. So governor functions to Parliament, legislature functions to Parliament. So it's all Millard's. The power is concentrated in Parliament to do what it likes. And in particular, the reference to Section 91 of the state constitution to the governor and to the legislature of the state or the houses thereof shall be construed as references to the president and to Parliament, or to the houses thereof respectively. So, Malas, you lose the link between the center and the state altogether. You absorb the powers of the state with yourself as the executive as well as Parliament as the legislature. And you decide without reference to any other institution. Governor means president, legislature means Parliament. So you can do what you like. And so you give yourself consent. You don't have to seek consent. And the people who gave themselves this constitution are left out of the process altogether. This is essentially, according to me, a breakdown of the constitutional structure that was engrafted in the Constitution. It's a complete breakdown. By inhering in yourself as the union, the power of the state, executive power of the state, and by Parliament, the legislative power of the legislature. So you do away with any representative form of government, do away with institutions, and make it irreversible.
Yes.
Then let's go back now to the list of dates. PDF 48. Written submissions compilation volume 2, PDF 48. So I've done with the proclamation 1912-2018. So item 60. My lords had that. A resolution approving this proclamation issued by the President on 19/12/2018 was passed in the Lok Sabha on 28/12 and the Rajya Sabha on 3rd of January. Then, brothers, we don't have to read this. Jammu Kashmir peoples, we're not concerned. Kindly come to 60, item 65, PDF, page 50. So at item 65, you will find on the 3rd of July, 2019, the President's proclamation was in terms of Article 356(4) to expire on 2nd of July. 6 months, mothers. Because from January 3, 2019, it would be July 3. So it was to expire on 2nd July. Consequently, President's rule in J&K was extended for a further period of 6 months with effect from 3rd of July till the 28th of June 2019 and Rajya Sabha on 1st of July. Then leave all this. Then 72, page 53, PDF page 53. This is that 11 a.m. order on the 5th of August 2019.
We'll break here. Mr. 3 minutes short. We are going to the 11 a.m. order now. We'll continue with this on
We'll wait
Tuesday.
for 11 a.m. the next day. I'm deeply obliged. We appreciate your Lordship's patience, Madam.
We'll come back on Tuesday.
Yes.
Tuesday, no?
Lordship, on the matter, the High Court has pronounced the order that my Lord had remanded to them. We filed an SLP against that. We sent the email as per the protocol,
Certainly.
requesting for a listing. Lordship, because they may not proceed with the survey.
I'll look at the email right away.
Wait for Lordship. Wait.
Spare the unnecessary hassle. Sign documents from your smartphone quickly and easily. Bitrix 24 Sign. Free, convenient, and easy to use. For you and your clients.